And we'll call up Tom Lambert, Michigan Open Carry, wishing to speak in opposition to the bills.
Good afternoon. Thank you for the opportunity. As you've heard, this is not the first hearing on these bills. There was another hearing before. We've heard lots of testimony in that hearing in the House, lots of testimony in here. And the biggest thing to take away from all of that testimony is a big, fat zero in terms of incidents that could not be handled under existing law. 0 incidents that could not be handled under existing law. And please, it makes absolutely 0 sense to make more mass murderer empowerment zones like MSU. There's 0 logic in doing something like that. Do not make more of those zones. But when it comes to understanding existing law, understanding what's actually in these bills, there's been a lot of testimony on things that effectively don't exist. It's not existing law. It's not in this bill. Are these bills about open carry? Are these bills about banning guns in polling places? It's really not clear because nobody's actually talking about reality. So let's actually look into the bills. Go through the language, because that's what we're here for. We're not just here to talk about feelings and emotions. Let's actually talk about what's in these bills. In 4127, subsection 4, subdivision A, applies to a peace officer acting in the course of the officer's duties. So I guess peace officers that are going to their place of to their duty or coming home from duty, they can't possess a gun in these polling locations. They have to be on duty only in order to possess a firearm, I guess not just in, but outside of these polling locations too. And we're not just dealing with polling locations. I keep hearing Bruin talked about polling locations. Okay, yes, polling locations were mentioned in Bruin, but unlike other attorneys, I'm not going to lie to you and say that the Supreme Court held anything because I understand what dicta means. And so when you have police officers, they're not in the course of their duties, how do they get around without violating this law? Is it okay if they stop and vote on the way home from duty? What about if they vote on the way to duty? How about subdivision B, a person who purchased or possesses a firearm in that person's residence or that person's private property? What if I'm at somebody else's private property? Or if I'm at my private property and I need to leave my private property to go somewhere? I can't do that under this law. Because as soon as I leave my private property and I enter the sidewalk, and that sidewalk's within 100 feet of the entrance of any one of these numerous different places that, again, are more than just polling locations, I can't do that. And yes, that absolutely does violate the Bruin decision. So is there a history and tradition, because that's what the threshold, the framework was in Bruin, is there a history and tradition of prohibiting otherwise lawful firearm possession out in public? Again, Bruin held that there's an individual right to possess a firearm in public. Is there history and tradition of prohibiting that? No, there's not. Is there history and tradition of prohibiting it within 100 feet of one of these places? No, there's not. How about subdivision C, a person carrying a concealed pistol if that person is licensed by this state or another state to carry a concealed pistol? A lot of these people don't necessarily have a license to carry a concealed pistol. Some of the officers I talked about, a lot of officers don't have them because they don't need them. You then get into subsection 5 as 3C does not apply to a person who's lawfully transporting or possessing a firearm in a vehicle. But that's only for 3C, which is for the drop boxes. 40 days before an election, possesses a firearm within 100 feet of any of the absent voter drop boxes. It doesn't apply to while the polls are open on election day, possesses a firearm in a polling location or within 100 feet of any entrance to a building in which the polling location is located, or B, on any day early voting is conducted at an early voting site, as described in yada yada, possesses a firearm at an early voting site or within 100 feet of the entrance of the building of the early voting site. It's my understanding these places can even move around, and they're all over the place. You can't transport a firearm past them. These are sometimes even in parking lots. I've even heard of gun clubs being polling locations. None of that applies. Let's go to 4128. Again, we have that with 100 feet of any entrance to. But here, the only exception does not apply to a uniformed law enforcement officer. Okay, so what about our non-uniformed law enforcement officers? What about federal law enforcement officers? Is that in here? Because one says peace officer, other says law enforcement officer. We have different terms. They're not being used consistently. They're not being applied consistently. The confusion here, it's like nobody really took time to figure out what really are we doing here and what is our goal and how do we really want to make this work. Because the problems are obvious and numerous. What about church security? We said, well, guns are banned in church. It's one of the things you heard. No, they're not. They're absolutely not. And thank God they're not banned in churches. We know churches can be targets for people who want to do a lot of harm. And thank God they are not gun-free zones so that they can defend themselves. But guess what they have to be while they're a polling location? That's unfortunate. And I know a lot of religious events occur in other portions of a church on polling days. They just give the main area to be a polling location, still hold an event elsewhere. You take a look at poll workers. You want to know who a soft target is? Someone who's not going to be able to defend themselves. Any poll worker leaving a polling location. State law does not allow them to protect themselves. So I know if I'm a bad guy and I want to target somebody, I'm looking for a soft target. Any poll worker leaving a polling location, probably driving home from a polling location, any one of them, congratulations, will now be a soft target under this law. 18 to 20-year-olds. Sorry, you guys, you're out. You can't get concealed pistol licenses. You don't have that exemption to you. You are not going to be able to possess a firearm walking down the street during certain times of the year in a lot of areas, especially inner city areas. And let's talk about the inner city thing. Because what is this really going to result in? It's going to result in the same thing the vast majority of our other gun laws result in. Prosecution of inner city minorities. Let's be honest about that. It's not going to be rural areas because you can get around a lot easier in the rural areas without crossing in front of one of these zones. The inner city areas, especially where this stuff is actually going to be enforced, that's where this will take effect. Specifically against a lot of inner city minorities, just like we see each and every day. Watch some of these hearings that are broadcast on Zoom. You can see the effect of our gun laws already. But does that mean we do absolutely nothing? I just want to be very clear because I know somebody's going to say, well, we should do absolutely nothing, and not saying that. The existing brandishing law, which I helped write the definition for, already applies today. It applies to anyone who points, waves about, or displays a firearm in a threatening manner with the intent to induce fear. I heard situations where somebody's afraid of exactly that happening. Okay, we got a law for that. Already in the books today. Can already handle those situations. Like I said, there were 0 examples mentioned in all of that testimony of a situation that cannot be handled under existing law today. I hope you will, at the very least, fix the multitude of problems in these bills. I'm happy to answer more questions on them. Thank you for your time.
We have a question from Vice Chair Johnson.
Thank you, Mr. Chair, and thank you for coming today. It sounds like you and Sherry both, one of your concerns, there's numerous, but one is that for 40 days, it would be illegal for someone that might not even know where a drop box is at. Like we have one city that has 30 drop boxes. And if you don't know where they're at and you walk by or drive by, you would be in violation of the law for 40 days. Is that what you're suggesting?
For the drop boxes, there is a specific exemption just for the drop boxes that applies to a person who is in lawful who is lawfully transporting or possessing a firearm in a vehicle. However, when it comes to carrying, especially when you have somebody like 18 to 20-year-old who cannot get a concealed pistol license under Michigan law, they have no options here. And so they could walk down the street and absolutely run afoul of this law, simply walking down the street and going past a box of, I didn't know what that box was, until the officer who's watching that box and watching for anyone who might have a gun stops that individual who had no intent of doing anything wrong, was just caring for their own personal protection, but now arrests that individual and charges them with a gun crime.
Thank you.
Senator McMorrow.
Thank you, Mr. Chair. I want to follow up on a couple of statements that you made. Number one, you said that by putting these laws into effect, that it would create a situation where poll workers leaving a polling place would be soft targets. In the state of Texas, has there ever been an incident where a shooter has targeted a poll worker leaving a polling place?
I'm not familiar with the data from Texas.
Thank you. You also noted that there have been 0 instances and that these laws are unnecessary. Is it the opinion of you and your organization that all of the rising threats and threats of intimidation against election officials and poll workers, which are very well documented, do not count as incidents?
It is the position of my organization that if somebody is going to do something wrong that's already a felony or a very, very serious misdemeanor, that a 90-day misdemeanor is going to do absolutely nothing to that person's choices.
So again, I want to ask the question, so your opinion of your organization is that the well-documented threats to election workers, election officials that are causing election workers to leave in record numbers is not an incident?
Those situations which are already punishable under more severe laws, that this less severe law will have no change on those incidences.
The rising numbers have existed under existing law. So again, you're saying those are not worthy of consideration.
And how is this going to change that trend?
Thank you very much.
We had actually a comment from one of our previous people who was testifying who wanted to clarify something that was said. So I wanted to pull up Robin Sanders from Zoom, who wanted to make comment.
Yes, thank you, Mr. Chair. I just wanted to respond to a couple of things that was said in the gentleman's testimony and some of the predecessor individuals. So I inspected both House Bill 4128 and House Bill 4127, and both explicitly exempt individuals who are licensed in this state or another state to carry a concealed weapon. So the concerns that have been voiced today about individuals who are licensed to carry concealed somehow being criminalized under these laws is inaccurate based on the express language written in both pieces of legislation. And then I also wanted to respond to a factually inaccurate statement that was made about the Bruin decision. As we noted, and several of my colleagues noted in their testimony, that the Bruin decision does in fact say that it is legal to regulate the possession of firearms in sensitive places, including polling locations. While the test that was adopted in Bruin requires courts to see whether or not there is a historical analog for the particular gun law that is being challenged, this language comes directly from the opinion. It says, quote, "To be clear, even if a modern day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster." And then it goes on to enumerate a number of examples of laws that are not parallel or identical to the law that's challenged, but are sufficiently similar enough to where the law should pass constitutional muster. And so we believe very clearly that ballot drop boxes, election counting facilities, and the like would be sufficiently analogous places under the constitutional test to pass constitutional muster for a law such as these. And so I just thought it was important for the committee to hear the response and to clear up some of the factual inaccuracies that were mentioned in the testimony.
Senator Johnson.
Mr. Chair, if I may respond.
I'm going to defer to the Vice Chair of the committee. Senator Johnson.
Thank you, Mr. Chair. We have two different bills here, and on 4127, on the last page, line 8, subsection 3, it says, "Does not apply to any of the following: a person carrying a concealed pistol, if that person is licensed by the state or another state to carry concealed pistol." But on the other bill, 4128, on page 2 at the bottom, starting on line 22, it says, "A person shall not possess a firearm arm in an absent voter counting place or combined absent voter counting place or within 100 feet of any entrance to an absentee voter counting place or combined absentee voter counting place. So there's no exception for CCW in one of the bills the way I read it. There is in one and not in the other. So 4128 does not give an exemption according to the language.
All right. I'm going to read in cards from those who submitted a position but did not want to testify. You have further testimony?
If I may very briefly respond.
Very briefly.
Very briefly. Exactly. The CPL exemption is not in one of the bills. It just does not exist. That was incorrect. Further, the concerns in 4127 applies to people that don't have the CPLs, well above and beyond that. Lastly, as any attorney knows, or at very least should know, any comments in a court decision that don't pertain to the exact issue before the court are what's called dicta. They're not binding. The court has yet to set a framework as to what sensitive places can be. They can say we might presume some of these are sensitive places, but that doesn't actually count as a holding. It's called dicta. And lastly, when we're talking about polling places, again, a lot of these bills apply to areas that are not polling places, well above and beyond and outside of polling places. So even if the Supreme Court were to say, yes, a polling place is a sensitive location, that doesn't make everywhere outside of it, which is the crux of a lot of my concern here. Thank you for your time.
Aaron Shore from the Department of State, not wishing to testify in support of the bill. Bill Zagman, representing the Michigan Association of Municipal Clerks, not wishing to speak, supports the bill. But Kim Meltzer, the Clinton Township Clerk, not wishing to speak, opposing the bill. We have Linda Danders from Lansing Moms Demand Action, not wishing to speak, supporting the bill. Brady Schickinger, Michigan Coalition for Responsible Gun Owners, not wishing to speak, opposing the bills. Judy Karanjeff, League of Women Voters of Michigan, not wishing to speak, supporting the bill. Paul Dalrymple, representing himself, submitted testimony in opposition to the bill. Kelsey Rogers, Campaign Legal Center, not wishing to speak, supporting the bill. Brendan Boudreau, Great Lakes Gun Rights, not wishing to speak, opposing the bill. Logan Vorse, Michigan League of Conservation Voters, not wishing to speak, supporting the bills. And Marissa Kovach, ACLU, we spent all day together, not wishing to speak, supporting the bill. I need a motion, unless there's anything else that committee members would like to say, I need a motion to excuse Senator McBroom, so moved by Vice Chair Johnson. Without objection, the senator is excused from today's meeting. And that concludes our business today. So being no further business, the Senate Committee on Elections and Ethics is now adjourned.